Okay, time to start the meeting. If everybody will stand and join me in the invocation and the pledge. Heavenly Father, again, we come to you with our hearts open, God, to your grace and mercy. God, we thank you for that most of all. Lord, just bless us here tonight as we do the business of the county. Lord, bless our citizens, bless our country. Lord, we just ask that you heal our land. We ask these things in your holy name. Amen.
Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. First order of business is the approval of the agenda.
Motion to approve the agenda?
There's one add-on item, the right of entry agreement.
And then I'd also like to pull item number 16 from the agenda this evening, please.
I'd like to pull number 10 from the consent.
Okay, hold on. We're adding what's your item again? I couldn't understand you.
The add-on is the right of entry agreement that was sent out to you previously.
With Jerry.
All right. Okay, and you're going to pull item
16.
16?
Yes, sir.
And Chuck, you had
Pull item 10.
pull item 10 off, okay,
Consent.
for discussion.
Yeah.
I'll modify my motion to reflect that.
Second.
A motion and a second by Commissioner Thomas. Any more discussion? All for the motion?
Aye.
Aye.
Opposed? Motion carries 5-0. Next is citizens to be heard. None at the beginning. By the way, if you desire to speak, you can speak on any item. Just fill out a card that's on the agenda tonight, or there will be another citizens to be heard portion at the end of the meeting. So feel free to do that if you do so. All right. So the next item is the public hearings. And the first public hearing is on the 2021 proposed millage rate and tentative budget. So this is the time that we'll go ahead and do that, and I'll read this into the record. This is the first of two required public hearings on the Wakulla County budget for fiscal year 2021. If you wish to speak during the public hearing portion of this meeting, please step forward at the appropriate time. The tentative aggregate millage is 8.0000 mills, which is 3.87% more than the aggregate rollback millage rate of 7.7022 mills. Now the county administrator will read the tentative budget rate into the public record.
The proposed Board of County Commissioners of Wakulla County tentative countywide millage rate is 8.0000 mills, which is 3.87% more than the countywide rolled back millage rate of 7.7022 mills.
Okay, I'm opening the floor for a motion to begin the public
So moved.
hearing.
Second.
Moved by Commissioner Merritt, seconded by Commissioner Thomas. What y'all said?
Unanimous,
Same time. All right, we'll go with Commissioner Thomas. All right, so all for the motion to begin the public hearing?
Aye.
Motion carries 5-0. At this time, the individuals that have turned in a speaker card can speak. No citizens. Is there a motion to close the public
moved.
hearing? We'll have a
Second.
motion and a second to close the public hearing. All for the motion?
Aye.
Opposed? Motion carries 5-0. Florida statutes require the board to address the tentative millage rate before addressing the tentative budget. The board must vote on the millage rate and the budget separately. I will now entertain the following motions. We'll take each one separately. First is to approve the Board of County Commissioners fiscal year 2020/2021 tentative countywide millage rate of 8.000 mills.
So moved.
Moved by Mr. Merritt, seconded by Mr. Hess. All right, any more discussion? All for the motion?
Aye.
Motion carries 5-0. Number two is to approve the Board of County Commissioners fiscal year 2020-21 tentative countywide budget as presented by the administrator on July 15th, 2020, and is amended through the agenda process today.
So moved.
Moved by Mr. Merritt,
Second.
seconded by Mr. Hess. Any more discussion? All for the motion?
Aye.
Motion carries 5-0. The second and final public hearing for approval of the final millage rate and budget will be held on Monday, September 21st, 2020 at 5:01 p.m. Okay? Takes care of that. Next item of business is, public hearing number 2.
Those used to take 2 or 3 hours.
Thank you, Mr. Chairman. This item is a request for the board to conduct the public hearing and adopt the annual rate resolution for your solid waste services assessment.
So moved.
Second.
Okay, we have a motion and a second to approve the annual rate resolution for solid waste service. Tell us, Heather, what that rate is.
It is $196 per dwelling unit, as it has been for several years, and this is a public hearing.
I want to make sure the public knew that
No
was
increase.
increasing. Okay? Any discussion? Any citizens to be heard?
And I got to give Ralph credit, if I could, for pointing out in the contract many years ago that they have an increase, but they are allowed to have an increase. It didn't say they will get one. And
Right.
Ralph
Not-
rightfully pointed that out.
Not
and They
automatic.
haven't had one since.
Yep.
They never got one. So I appreciate your
Okay,
diligence
we have a
on that.
motion and a second.
Thank you.
All right, we have a motion and a second. Is that right, Kelly? Okay. Any more discussion? All for the motion?
Aye.
Motion carries 5-0. All right. Public hearing number 3.
Thank you, Mr. Chairman. The next item is to have the board conduct the public hearing and adopt the annual rate resolution for the fire services
So moved.
assessment.
Second.
Motion and a second. Again, tell us what that rate is.
There are several rates. They are the same as, they didn't go up this year, did they? They did not go up this year. The residential rate is $102 per dwelling unit. Non-residential is .1193 per square foot. And then the land rate is .2239 per acre.
And why was there no CPI increase this year?
We had a large increase in the customer base, and currently we're on projection with the fund balance, and there was no sense in over-revving it. Next year, we will be looking at an increase.
So I thought we had one time discussed every year doing the CPI.
We had, but we made we decided we'd recommend to you guys not to
Okay.
increase that based upon the pace of the.
Make sure going
fund
forward in
balance.
the future that, just because we didn't do it this time, that doesn't mean we're
Right.
not going
No,
to do CPI.
That's right.
No more discussion? All for the motion?
Aye.
Aye.
Motion carries 5-0. Public hearing number 4.
This request board approval to conduct a public hearing and approve the purchase and sale agreement for the acquisition of property in Magnolia Gardens.
So moved.
Second.
Moved by Mr. Merritt, seconded by Mr. Hess. Any citizens to be heard? Any more discussion by the board?
This is to help reroute an existing road that's right now run on private property, because it can't go through the platted right of way because there's a swamp there.
That's right.
All for the motion?
Aye.
Motion carries 5-0. Okay, awards and presentations, there aren't any. Consent,
Move consent?
with number 10 being pulled.
Yes, sir.
Okay.
Second.
Okay, we have a motion by Mr. Thomas, seconded by Mr. Hess.
Oop, I moved it.
Oh, you did?
Mm-hmm.
He seconded, I just continued.
He's got to quit he's moving on everything.
I know it. Chuck messed us up by
All right,
throwing a
motion by
second.
Mr. Merritt, seconded by Mr. Thomas. Okay, all right. Any more discussion? Any citizens to be heard? All for the motion?
Aye.
Aye. Motion carries 5-0. Okay, Chuck, number 10.
Every year I see this, it just offends me. We need to do something about this parcel, get acquisition, acquire it, do something, so we don't keep spending $25,000 a year for nothing.
And if we could get them to sign, isn't there some paper they'll sign and DEP will release us from the testing, and they won't do it?
That's right.
It's, this is the old dump that the county didn't buy the property, they just leased it, basically. It belongs to Alan, what's the last name? The plumbers.
Lofton.
Yeah.
Lofton's.
And
Yes.
this is a problem we inherited.
It's a simple solution. And
Simple, let's sign a form, but,
And we still have a suit that's hanging
We have
out.
a suit hanging out.
and as long as this is not resolved, Chuck's exactly right, we could pay this till the end of time.
Yeah, we've already spent, almost $500,000 on this piece.
Well, we're going to be bringing a resolution here shortly, as soon as we figure out a few more legal maneuvers.
So I just,
Do eminent domain, I guess, right?
I'm encouraging something to happen here, because it's just a waste of taxpayers' money.
I agree.
Agree.
Okay, so do you move to, who's moving?
Motion to approve.
Okay, motion by Mr. Hess to
Second.
approve, seconded by Mr. Merritt. Any more discussion? All for the motion?
Aye.
Motion carries 5-0. Okay, general business. David? Number 14.
Yes, Mr. Chairman, this is a request board approval for the BOCC to pay legal invoices incurred as a result of the Second Judicial Circuit Court Case 2020 CA 00043.
So moved.
And Mr. Buddy Wells is here as well.
Second.
Okay, we have a motion to approve and a second by Mr. Hess. Buddy, do you desire to say anything, or did you just hear if we got questions?
I'm here if you have questions.
Okay,
I got questions.
all right, come on up, Mr. Wells.
Gil, you get a pass for a little bit longer.
Welcome, sir. I just have a few things that I'd like to clear up. There's a lot of confusion about this issue, and I just want to see if we can maybe get on the same page. The first, I have a question of why you needed 2 attorneys to defend this case.
I don't know. I turned it over to my attorney, and he took it from there
Okay.
to give you a reason why. And I'm going to tell you right now, it makes me sick to my stomach that the kind of money we spent, $88,000, over a case that, I haven't understood since the first part.
I think we agree on that, and I don't think any of us wanted to be here, but I think that we took some steps to avoid being here, and it seems like we got here nonetheless. On June 3rd, you stood out here and you told us that you would be running partisan elections, okay? And you, correct me if I'm wrong, it's all part of the record. On June 4th, you made a Facebook post, and I'd like to...
Ralph, let me go ahead and stop you right there if you don't mind. Being this is still an open case,
Okay.
where I'm the office's defendant, you are the plaintiff, I've been instructed not to comment on anything about the case.
Okay, and I'm fine, and I'll just make my comments as a part of the record here.
Okay.
So on June 4th, 2019, on your Facebook page, there was a post that says, "Please read, very important. Supreme Court, in its opinion dated April 18, 2019, has determined that nonpartisan elections for constitutional officers to be deemed unconstitutional and invalid. Therefore, moving forward, starting with the 2020 elections, candidates will be running as partisan candidates with the exception of the school board and judges." And that's your post. That's not my words. That's your post, and that's in line with what you told us here on June 3rd. And I understand if you don't want to comment, that's perfectly fine with me, but I just want to get this out there for the record. I was under the impression, based on report from the county attorney, that you and her met and we were all in agreement that this should be a quick ruling, a non-adversarial case. In the first trial that you and I both participated in, you made a comment that you would like an answer from the judge as well, so you knew how to properly do your job, and I agree with that. And I'll say now, and I've said it before, whether this ended up partisan or nonpartisan with the judge, I don't care. The problem is we ended up splitting the baby. We ran some constitutional officers partisan and some not, and now we're in the mess that we're in now. We tried to avoid that, but that didn't happen. So I would think that we could have been in agreement to move forward in a non-adversarial way, and instead, once your attorney showed up, they started asking for discovery, they started taking the full time, they started running a normal case as if you're a defendant. We weren't accusing you of doing anything wrong. We had to have a plaintiff and a defendant, but they started running an entire case that has now ran this meter up, which is why we're here today for this $47,000. Had we not done that, had you not put up that big defense, we wouldn't be here trying to spin this. And obviously, I mean, I've got to vote for this because the county's got to pay its bills. But I'm telling you, I'm doing it with a bad taste in my mouth. This is the second vote I've had to make today that we're wasting taxpayers' money, and I don't like it. So I want to get this out there on the record. It seemed to me that whether it was your attorney or what, somewhere along the lines, a decision was made not to move forward unless both sides ask a simple question of the judge and get the judge to rule. Again, I wouldn't care what the answer was, but we needed to have the answer to that. I'm going to leave it at that.
Yeah, well, my request was, and you heard me when I mentioned it, let's get an answer. That's what I wanted.
Well, yes,
I'm no lawyer, and I have,
You did say that, and I believe that you meant that, and I certainly meant it, and I think that we had ample time to get that decision before the primary, except then we had lawyers get in there and gum up and slow down the works.
And nobody hates it worse than I do.
That's what I'm frustrated by. We could have got an answer from the judge months ago.
Right.
Yeah, but we did put it before the people twice, and they both times they voted for
Understand.
nonpartisan elections.
And the judge may have upheld that. And if the judge upheld that, we would be in the clear. Everything would be good, because now we've got a ruling. If the judge went with the Supreme Court decision, we would be in the clear. We'd have a ruling. Either way. I didn't have a preference one way or another, except let's not split the baby. Let's make a decision. That's all I have.
Okay.
I don't have a question for Mr. Buddy, but I do have a question for Commissioner Thomas.
Mm-hmm.
So, when you said we were wasting the taxpayers' dollars, and maybe Mr. Buddy will have to answer this, you mean just by paying this now up front instead of setting up a line for him to pay us back, or?
No, because the taxpayers are going to pay it either way.
Okay.
And just so the public knows what you're talking about, Mr. Buddy has the money in his account, but it's not budgeted, so he can't just write a check. So that brings us into it. We're going to have to pay it on his behalf from general revenue, and then if this board so chooses, we can recover that money from the supervisor of elections office back into general revenue. But either way, the taxpayers are still out the money. Yeah. My point is had the attorneys not put on a full defense, go into discovery, drag this thing out, increase their billable hours, we could have walked hand in hand to the judge and say, hey, we've got a conflict here, we're confused. The Supreme Court has said one thing in Orange County, our charter says another thing, our voters have upheld our charter, which do we follow? We should have all been in agreement that we want an answer to that question, regardless of which way the answer fell out. And that is my whole point, is once this other attorney got involved, this became a full defended case. Let's try to, throw the case out. Let's try to eliminate plaintiffs. Let's try to say that one plaintiff is not. All that is all legal technicalities, but at the end of the day, we just needed an answer, which is the right way to go. We should have all wanted that answer.
Well, I'm not as passionate about it. I agree with everything Ralph has said.
We still don't have an answer.
We still don't.
So are fees still accruing now with that same law firm?
Mr. Buddy, you have to answer that. I don't know.
Buddy, are we still accruing fees even though we still don't have an answer to today?
No, not that I'm aware of.
So your attorneys are through,
Right.
and this is their final. Okay.
Now the judge still hasn't ruled on our final case, so that's hanging out there. And
Yeah, and unless it, if it goes forward, there'll be more, but Wayne is my legal on retainer, on Mr. Mulaney. And
So is it possible that the judge could cause it to go further? Is there probability that we could have more lawyer fees out of it?
After the original proceedings, we were getting very close to the primaries, and then obviously now we're getting close to the general, and so we purposefully put the brakes on it so as not to have a ruling come down a week before the primary, for example, that would cause Buddy's office to have to completely change tactics. We did not want to disrupt the election, and so what will happen now is most likely a summary judgment motion will be filed, and that matter will be decided after the general election. So hopefully for the next election we will have an answer one way or the other, but we did not want to disrupt this election given the close timing.
And my concern is, depending on what this judge rules, this could affect elections that are in play right now. Right now, this matter is still not settled. If the judge says you should have followed the charter until the charter was properly overthrown or amended, then we just elected some constitutional officers that didn't follow the charter. If the judge says you should have gone with the Orange County decision, then we shouldn't have followed the charter at all. So I mean, this potentially affects the outcome of several races, which I don't know, I'm not an attorney, but it seems like it could open the door to someone could say, well, I would have won or I wouldn't have lost had we done one or the other. But that's the whole problem here, is we've left it uncertain, and had we gone to the judge and we had certainty, and the judge may say keep exactly what you got, then at least we're all clear.
Exactly.
Okay.
Now, the county is not, there's no more legal bills that will be coming to the Board of County Commissioners on this matter.
On that matter.
Unless
Okay.
Buddy's budget has additional legal fees on his side.
Okay, thank you, Buddy.
Yeah.
No citizens? Okay, we have a motion and a second. All right, any more discussion? Hearing none, all for the motion?
Aye.
Opposed? Motion carries 5-0. All right, next item.
Thank you, Mr. Chairman. The next item is just an informational update regarding the potential civil action against Brad Harvey, the suspended Wakulla County property appraiser. You all aware of the history in the past that most recently culminated with his arrest and removal from office back in April. At the time in April, we had some preliminary audited findings that showed the potential scale of the alleged misappropriation of funds. Mr. Harvey's not been tried or convicted of any crime and is innocent until proven guilty. But at that time, the investigation had identified just over $200,000. You will recall that the clerk had opened up some prior year's audits to identify if there was additional monies, and so this agenda item is bringing that information back to you and also providing you with some follow-up on any potential civil causes of action that you could bring against the suspended property appraiser. Now, I can go into this as much or as little as you want, and Greg James is also here to discuss the audit aspects if you have questions for him.
Definitely not for Greg.
So in sum,
Or do we want to read any of this into the record? It's
I-
up to you.
I can summarize if you want me to.
Please
I
do
think the
that.
gist of what we,
Now, let's let her summarize, Randy.
So in sum, the total alleged unsubstantiated expenses identified by the auditor are just under $240,000. The county has a fraud and theft policy, so you have recovered $100,000 of that from insurance proceeds. The civil claims, you guys had previously elected to let the criminal process sort of run its course under that criminal process, depending on how it breaks, but there is the potential for restitution, and that is pretty standard to have restitution to the victim. So if there is a guilty conviction or a plea bargain, restitution would likely be a part of that, and so those monies could be recovered through that process. However, there are a couple avenues of civil actions that you could pursue if you wanted to in the future. One is civil theft. A civil theft action is exactly what it sounds like, and this action would be able to, you'd be able to recover, if you're successful, not only the amount of money that was allegedly taken, but there is often the ability to recover additional damages and attorney's fees as well.
if the person has money.
If they have money. The statute of limitations on this is told actually during a pending criminal prosecution. So you would have basically 5 years and then 2 years after the criminal prosecution is done, so a full amount of time in order to bring this matter forward if you decided you wanted to do that in the future. So you could sit back and watch and see what happens with the criminal prosecution and see what happens with the restitution aspects of that criminal prosecution. Another potential cause of action is conversion, and this is a tort, which is basically they have improperly taken property that belongs to somebody else. This one has a 4-year statute of limitations. Generally, with torts, you have the concept which is called a continuing tort, which is a series of the same tort over time, like individual takings of money. Each one does not have to be looked at as a separate tort. So you would have 4 years from the, what was that, Randy?
What's a tort?
It's a like personal injury is a tort, it's a civil cause of action for damage to person or property.
I'm not a lawyer, like, you've heard that about 10 times tonight, so I thought
Sorry.
I'd say it too.
And so, under the most conservative interpretation of the statute of limitations for a tort, you would have 4 years from the date that the last portion of that tort cause of action was accrued. So that would be 4 years from when he took office, so January of 2021. But with the continuing tort theory of recovery, I think that you would have a much longer period of time than that. I give you the January 2021 date in an abundance of caution so that you don't have to have any sort of argument with the statute of limitations. But I'm pretty confident with the case law that is out there that you would be timely even if you waited longer. So you don't have to make a decision tonight. Just wanted to give you guys a little bit more food for thought on this aspect, and you guys can, I'll keep you posted as we hear about the criminal prosecution. I haven't heard anything, but as we do, we will definitely keep you posted on that. And additionally, we just wanted to give you guys some information on the time periods, so that when we do get closer to that, you'll have the information you need to make a decision.
I think the board direction was basically to just sum up everything Heather just said. We decided to just hide and watch, and nothing's really changed.
You did, but you did, I think Commissioner Thomas asked for these time periods, and so that's why we're bringing this back,
Gotcha.
along with the auditor's report, which was not available the last time we talked.
And so this is the last time that we're going to, there's not going to be any more new discovery of numbers appearing. This is it.
We hope not.
Great.
Not
Thank you.
that-
You're welcome, Randy.
You knew Greg wanted to get up there.
Can't keep him
Yeah.
away.
Couldn't wait.
So our ex-auditors audited a 7-month period of fiscal year 2019-20, the year we're in.
Okay.
Our new auditors will not rely upon that audit.
Okay.
They will audit themselves the entire 12 months. So as I put in my letter, they may find things that the previous auditor did not.
Okay.
So
But we're not
the numbers
going
are
back
still subject to change.
2016
We're
and
going back any
we're
more
done.
years?
This is it.
1 year.
Okay.
Just normal annual audit.
Exactly.
Pleasure of the board, we're just gonna idle along and make some
Yes.
decisions later?
Yeah, it sounds like we've got time, and it sounds like you're saying that we may have 4 years after whatever the last tort event was, so if there was money misappropriated in this year, then we've got
Exactly.
4 years from now,
Yes.
And I-
2024 potentially.
I feel pretty confident about that, but it's not, in making that call, you're relying on case law where the facts don't completely line up, so anybody defending that would likely make that argument that this is untimely, and so those earlier torts should be off the table. But I think that the ongoing misconduct and the pattern of misconduct it falls on your side to give you a longer time period. And in any case, you certainly have the civil theft action, and that time period is pretty certain. Now, civil theft has a higher burden of proof than just
Clearing,
plain
compelling.
conversion, yes. But I think that you've got, from what I have seen and what I have been made privy to, you have some pretty good facts to go after on this aspect.
Yeah, but if the criminal action takes place, we could get the
Restitution.
our restitution from that, and we wouldn't have to take
We don't have to
legal.
pay any lawyers.
You would get, if restitution is ordered, which it most often is, you would be able to be paid back. Now, that would probably come over a period of time.
$50 a month or whatever you can afford to pay.
But again-
It's how all of it's gonna come in.
Yeah, even if you got a civil judgment, there's no guarantee that there's funds available to pay it anyway.
You get blood out of turn.
What's a typical penalty for failing to do the restitution?
I don't know. From a criminal aspect, I don't know. Now, civilly, obviously, you can get liens on property and go after any sort of assets that are out there. I don't know what assets are out there on this.
But that's not going to change whether we go civil or
Well, I guess, yes,
restitution.
it actually would, from what you just said now. If we do go civil, we could theoretically put a lien on any property has. If we rely simply on the criminal justice system, we couldn't lien anything. Whoever could pay $1 a year and whatever.
I mean, sometimes criminal restitution can be converted to civil judgments, but again, that would be at the conclusion of the
Still, I think we
criminal
still need to wait
process.
I do
for the
too.
criminal and see what happens.
And we've already been paid the 140,000?
You've been paid
I mean,
100,000
100,
through
and I
your
have
insurance
140,000
policy.
left. Okay,
Okay.
my notes, Randy.
Good for you.
Thanks.
All right, surprised you can read them.
So this is just informational. There's no action needed unless the board.
We've been paid by our insurance company.
Yes, I got it.
That's right.
All right,
Who's going to be looking for their,
item 19. Wakulla Cares.
Yes, Mr. Chairman. Sheree, could you please come up? This agenda item requests board approval of recommended revisions to the Wakulla Cares Community Rapid Response Program for individual financial relief assistance and individual relief. Sheree?
Yes, as you know, the CARES Act is evolving, and it evolves rather quickly. As other counties come online, you find out innovative practices that they have explored and have adopted, as well as the Treasury is updating their guidance almost daily. Had another update this weekend. And so based upon additional information and some from Integrity Group, from some of the work that they're doing in the counties west of us and the upland counties, and an unsolicited proposal from Career Source, I wanted to make sure the board had the opportunity to decide whether or not they would like to expand the individual relief to include child care services, so that if an individual is called back to work, you know, maybe they don't have a child care, and then they need child care because they're able to go back to work part-time or whatever, then we could expand and provide them some assistance, or if they need to go look for a job. I'm also working on a scope of services with Career Source to provide training, and hopefully we'll be able to get that in front of you within the next couple board meetings. And that way, if someone was unemployed and they wanted to do the training or go into an on-the-job training, then we could provide child care assistance for them throughout that period. So we're just trying to make sure that we give the most that we can in accordance with the Treasury guidelines to everyone.
And the other thing was the assistance for active military, correct?
The other one, right. And so what happens is we've got like 110, according to the census, active personnel military individuals in Wakulla County. And I spoke with our veterans officer, and apparently this is a bigger problem than I ever knew. But what happens is they may reside in Wakulla County because maybe they're National Guard, or sometimes they're even going to school to finish their degree, but they're still considered active military personnel. Well, what happens, their legal residence where they vote may be in Alabama, Georgia, California, so they're not considered legal residents of Wakulla County. So what this would do is this would allow those active military personnel and their dependents to be eligible for these funds as well, and this is what other counties are doing, so that they don't have to, say for instance, we would have maybe somebody that their legal residence was Escambia County, but maybe they're living in Wakulla because they're going to FSU to finish their education for whatever reason, or TCC or wherever. So then what would happen is without this provision, they wouldn't be allowed to seek relief in Wakulla County. They would have to go back and try and get relief in Escambia County. And so Integrity brought this to the table because the larger military counties have included this in their criteria.
Motion to approve the recommended revisions to the CARES Act.
child care assistance and active military personnel.
Child care.
I'll second that.
What Chuck said.
Okay?
And does
Motion and
the
a
motion
second.
include not approving the,
That's correct, which is, I think, is recommended by staff, so I
Right.
approve the recommended revisions.
which would include child care and active military
Correct,
duty
that's
personnel.
it. Yes.
Okay? Any more discussion?
I'd like to make a comment just to throw out. So someone gave me a suggestion today on the individual assistance, and let me back up. For the benefit of the public, you can go to wakullacares.com, and this assistance is available for individuals as well as businesses. But for an individual, it's there for rent assistance. It's there if they're behind on their mortgage, utility payments, things like that. There are people that have gone into debt that receive the same loss of income, but I don't think they qualify. Let's say
They have a direct grant program.
even though they're not behind on anything.
Yes.
The criteria from the Treasury was very clear, but we will always go back and explore all possibilities.
That
And
was
if it appears that we can expand it, we'll let you know, and we'll do an informational update.
But you're saying that require change. That's not as it stands
That's
today.
not what was presented to us. What presented to us is if you meet the income,
If you've lost the income.
you lost income, you can prove you lost income, yes, you get the check.
Okay.
And that's
Well,
exactly the point that I made when we first
I
presented.
remember you did, but I don't know that it doesn't look like that's what made it to the website.
That was what was in the last presentation to this board.
So that's what I want to clarify. Let's say you lost, $5,000 in income, and you maxed out your credit card $5,000. You never went behind on
That was
anything,
exactly my point.
but you had the same loss as people that did miss mortgage payments.
Yes.
Okay, I understand what you're saying. Let me go back and clarify that, and I'll just do an
That is the
email.
way.
I need to get with Heather and Integrity Group to clarify that.
Okay.
I know that was the case for the business side.
We have individual
It's
assistance
the
too.
individual that you need to check on.
All you have to do is prove you had a loss of income.
Right. That's what I hope, and that's
Yeah,
what I think. But
that's-
it doesn't. When I reread the website, it looks like you have to be behind on one of those things.
Well, I specifically said that.
That's the way I understood it in the last meeting.
Well, if that's the case, hopefully we can clarify
They need to
that.
clarify the website then.
We'll-
And I do know that Jessica Woodall, who Integrity hired, was one of the things they had told her to do is to audit the website to make sure that it was accurate. But if we find that, so as I'm understanding it, we want to provide that amount to individuals and be the most liberal in the interpretation as possible.
Right.
We want what was presented at the last meeting.
Okay, by Integrity.
And retroactive, correct?
Well, we won't have to worry about that because we
Right.
don't even start till the 15th,
Exactly.
which is
So
good news.
we've got time, and it's
Right,
coming together.
between now and then. And that's the good thing. Doing the 10-day public notice and getting the questions has really afforded us the opportunity to find these little issues. So it's all positive. And so that does give us an opportunity. Like tomorrow, I'm having a call with Integrity to go over the child care and the active military, and they'll begin immediately. So that way, by the time the 15th rolls around, these issues will have been resolved.
Okay.
I also sent an email to Jay Mosley. He's doing the rent assistance side of it. He sent out over 250 applications already, and they're starting to come back in now.
Good.
Wow.
The whole point of this was to get that money out in the community as quickly
Right.
as possible with as least governmental documentation
I'm
as
with you.
possible.
I agree.
But one other thing, if I may, and this is David and I, as well as Greg and I have discussed this, is right now the county's only received one agreement for our CARES Act money up to $1.4 million, and that's actually in our bank now drawing interest. We have to manage the money that we have and not go over that amount until we get our second agreement. Because we don't know when we're going to get the second agreement. We don't know what kind of provisions are going to be in the second agreement. We don't know if the second agreement would allow us to do pre-award costs, which would be anything that we spent over the 1.4 and before we got the next agreement. So we are proceeding with caution, and we'll be monitoring our obligations and our cost weekly, because that's when I'll be getting reports back from Integrity to make sure that we do not exceed what we have cash in the bank.
And I would stay behind that 1.4, obviously. I'm sure you guys are going to do that, not run right up to it, because we
Right.
don't want the next draw to come in and they all of a sudden say they got all these different stipulations with it that we don't have now.
Right.
And all of a sudden, if we keep giving money away, we're doing it, that might be illegal on the second draw. So I'd
Exactly.
bump up close to it, but
And that's
not
why we're
too
being
close.
very cautious, and I'm already collecting what the Wakulla County Sheriff's Department needs, what the Health Department needs, and then the county's expenses. So we're pulling all that together. as well, because that has to be our expenses and all of our, has to be figured in this 1.4, as well as our payment to Integrity for being the consultant and running the portal.
So you're going to do first come, first serve up to, say, 1.3, and then that's it, right?
We're probably going to look at it because I need to figure in all of the other costs that we've had, including county costs.
That's what I'm saying. All total
constitutional.
costs, first come, first serve. Once it hits 1.3, you're going to,
Yes,
whatever.
you will hear those gears
You're going to
downshift.
stop until we get the next bunch of money, then start it again. And that's, hopefully the qualifications will be the same, hopefully.
Hopefully we get the money before it's
Yes.
run out.
Yes, that would be ideal.
Or it's possible Congress could come back and allow some of that money to be for lost revenue, and so hold some of that back as
Yeah.
well.
So in the meantime, if you have any questions or you see any problems with the portal, just let us know, or let me know, or Jessica Woodall, you've got her number, and then we can make those changes and corrections as we go. All right,
you.
thank you so much.
Thank you.
I want to say something to Sheree,
ma'am.
please.
Yes, ma'am.
So I serve on the Career Source Board as a member of this board, and I really want to thank you for guiding me, helping me, being there. I really appreciate it.
Anytime.
Thank you, ma'am.
All right,
Thank
thank you.
Okay, that finishes general business.
We didn't vote.
You vote.
We didn't vote.
Sorry.
That's okay.
Motion to approve.
I already made the
You
motion.
already made, and I seconded it.
All right, there we go. All for the motion?
Aye.
Opposed? Motion carries 5-0. Thank you for correcting me. All right, so next is planning and zoning. There's no items.
There's an add-on item, our add-on item.
The right
Yes,
of
there
entry.
is. All right, go ahead.
This agenda item requests board approval of the right of entry agreement between Jerry Moore Florida Operations LLC and Wakulla County concerning property on Coastal Highway. What this is a 100-acre tract that we want to, before we go and enter into a hard contract, we want to make sure that it would fit our needs as far as a rib system is concerned.
Rapid
and
infiltration basin.
Rapid infiltration basin, as well as possibly a spray field and possibly a county borrow pit, but we don't, the biggest concern is getting area for rapid infiltration basins and or spray areas. What this would be is just test it, do soil testing, and minimal soil testing, and get out.
Motion to approve.
Second.
I told
Motion
David,
to approve and a second by Mr. Thomas.
I have found a lot of pipe clay in the park subdivision, so it'll
Oh,
be
yeah.
interesting to see.
Guarantee you that. Any citizens? No, there's, okay. Any more discussion? Not sure the park subdivision gonna be crazy about such a thing as this, but we'll see.
Ribs, I don't think would be bad. Spray field, they probably wouldn't like.
Where's the access point? Through the park?
No, the access, we're working with them to get an access out to 98.
Because we got to remember too, this effluent is treated to the absolute highest standard. It's not like the old spray
I
field.
know, but
And we have limited high ground, so.
It doesn't care.
Ned cares. I went on a field trip with him.
I said Ed.
Oh,
Ed's
thought
looking
you
a
said
little weird
Ned.
out there. No.
Okay.
Does he live
Not
in?
yet.
does he
all
live
right,
in
we have a motion and a second.
I'm having trouble spending money for an inspection of something we haven't got a hard contract on. That's my,
With due diligence is what I figure this is.
okay. You can call it that. I have trouble with that.
We don't wanna buy a pig in the poke either.
No.
So,
No, absolutely. And this
this
is,
is due diligence. We gotta do
Absolutely.
this
Well,
part.
usually in real estate, you get contract contingent upon, so.
All right, any more discussion? All for the motion?
all right.
Aye.
Opposed?
Aye.
Motion carries 4-1. All right. We have Commissioner agenda items, Commissioner Messersmith.
This is a request for board approval of a letter of concurrence for the Wakulla County Historical Society to apply for the National Park Service Hurricane Michael Subgrant Program.
If that's a motion, I'll second it.
Okay. Motion to down here, what was, make sure we got the right motion. So you're going with,
It's a letter of concurrence
letter
or a
of
letter of
concurrence.
support?
Concurrence.
the motion is to approve the letter of concurrence for the Wakulla County Historical Society to apply for grant funding through the NPS Hurricane Michael Subgrant Program, seconded by Mr. Merritt. Any more discussion? Any citizens? None here, none. All for the motion?
All right.
Aye.
Opposed? Motion carries 5-0. Thank you.
Thank you.
All right. Next is County Attorney. Any items?
Nothing additional.
County Administrator?
Yes, I have a couple of things, Mr. Chairman. We give you an update. Our septic and upgrade incentive program, we're in the process of establishing a budget for that to return back to DEP. It'll be, as of right now, this project or the program will be operated out of Planning and Zoning's office.
Which is different than the previous
Which is
round,
different.
which
It was
operated by the health
operated out of DOH. That's right. So, but anyway, we're developing those budgets. One part of that is a septic tank budget from BDI, not BDI, excuse me, Dewberry, and they're finalizing that today. We'll get that to DEP, and then at best, DEP said at best would be December before they have us a grant agreement. More than likely, it'll be into next year before we get a grant agreement. So it's still a little ways out, and just to give you an idea of that. So DOH also is doing COVID testing Tuesdays and Thursdays. I think we've worked everything out for the Wakulla Middle School stuff.
I think so.
Volleyball. Also the reuse at Wildwood, you'll be seeing another one of these access agreements coming in for that, for our RIB system there. It was part of our overall sewer plan. That's going forward. We'll be doing testing. We'll do the testing at the same time, utilize the geotech work. That'll be coming forward, as well as the PER. We're hoping to be going to SRF for SRF funding for our engineering or wastewater treatment system. We're hoping to have that in by the end of September, but I just got a call from our engineer. What's that?
You mean RLF?
No, the PER, the
You said
engineering
SRF.
report. SRF, State Revolving Fund.
Yes, I thought it was.
Right. So what?
Revolving loan.
SRF. That's right. So what our plan was to have it in by the end of September. Trevor called this afternoon, and it looks like we've run into a little bit of snag with SRF. They have more applications for their November meeting than they have funding, and so we're still we may or may not apply at the end of September and polish our application and get it into the next year. What that'll mean is we will have to go have to use some of our wastewater access fee funds for our engineering for our next train. That'll probably be to the tune of about $1 million. So
This SRF is going to be to add another pod to the plant to expand.
this would have been all of the dollars that are in that were in that plan. We were going to fund the SRF. Remember, we're going to have some funding out of the sewer fund, some funding out of SRF, and some funding
But I
from
mean,
the
it's not
Restore
to
Act.
retrofit anything that's already there. This is going to be a
it's a brand new
extended air.
between that and the Restore Act, yes, and also all of the transmission line increases that we were going to have,
Now, on
part of that as well.
the other stuff on the backside of the plant, like the chlorination and the sludge, the clarifier, or whatever. Is all that going to be able to?
Well, there'll be another plan will have the clarifiers and settling tanks and all
The
of that
sludge
stuff.
capacity's there, the bar screen on the
That's
front
right.
side.
All that stuff is supposed
None
to
of
be
that will-
sized to be able to handle that. That's right. Now, it's supposed to be sized to handle that. We'll wait and see. So anyway, we're progressing on that, as well as we also are progressing on we're identifying some tracks for our fire program that we talked to you about. We've got a design now for an area that we'll have to have, so we're applying that to a couple of pieces of property and checking out the 5 mile, and we'll hopefully be coming to you guys next month or following with some contracts on those, so we can go and secure those lands. And other than that, that's it.
Okay.
So the septic tank fund should come online sometime at the beginning of next year.
It's all according to DEP. It's in their hands.
Okay, and is it going to run the same as it did?
Run the same as it did, just run out of Summers' office versus DOH. And we got to wait. We also have to wait until we get the grant agreement in here, because we don't know all the details until we get the grant agreement.
In the previous system, the installer had to apply for the grant. Is that going to still be the case?
We have to get the grant agreement. Got to get the grant agreement.
Let me see the engineers, what they come up with on septic cost.
Yeah. Okay.
Okay. Next
Also, Woolly Park is being paved. It was started today, so we're going to have hopefully we'll have a little ceremony down there for reopening. I think y'all are going to like that.
Good.
And we all got the email about the community center in the Panacea also, so.
And next is citizens to be heard. We have no citizens to be heard. Discussion issues by commissioners. Commissioner Hess?
Yeah, I had a phone call from a Mr. Barwick about coaching. I assume, he said he called everybody, and he's had a violation 36 years ago, as there's no statute of limitations on when he was 19 years old when it
Here's
happened.
the policy.
Yeah, I understand the policy,
I guess, I was gonna talk about it too. The root thing is, do we wanna revise the policy? That's the only way.
that's the only way that could happen, and so the question is that you want to, I mean, for something that's, sexual in nature, I wouldn't want to revise the policy, but this was a bar fight when he was 19 years old, and it's been 36 years.
My suggestion would be, and it's just a suggestion, since we were gonna talk about it anyway, there's two separate things. There's sex offenses, that says never, and it also says felony, says never. Now, one of the violent felonies, all violent felonies are never, which one of those includes murder. I don't think anybody wants somebody convicted of murder out there with kids. So I would put murder on the same level as sex offenses and then make, say, 30 years. If you got in trouble 30 years and have not gotten any trouble since then you'd be eligible to volunteer. That's just my suggestion. Or we could just do nothing. Or we
Okay,
could
but
do
why do you, I'm just curious, why'd you pick the number 30?
arbitrary. Not gonna lie to you. It could be 20, it could be 28.
And when you say not gotten in trouble again, is that same offense or other?
I'd say not, well, I mean, I don't want a parking ticket, obviously, but
Right.
maybe say no felonies since then, I don't know.
Is this the, when Mr. Barwick called, is it one of those things that we have two rules in place here? This backs up the flag football or softball, or is that two things that have to match?
I don't know what the private leagues could have their own rules, and I don't know what those are. This is the county's volunteer policy.
And that has to follow, or the volunteer for the association has to follow this?
Yes.
And if the volunteer for the association is less stringent than this or more stringent than this, then we change this?
No.
Right. Okay.
Apparently the rule was changed in 2014. Before that, this exclusionary criteria was not there, I guess?
Before that, you didn't have any rules.
We didn't have a rule, okay.
So you
So-
put rules in place in order to safeguard.
I mean, it's, like Chuck said, Chuck, I don't know if you had another idea, it's really up to us, we could do nothing, we could
I just
revise
thought,
it.
if you haven't recommitted a significant crime in 30 years, you've changed your life. There's certain things like, a sexual offender, that's something that you'll have, those people are typically, the rest of their lives, you have to monitor. But a bar fight when you're 19 is a lot different when you're, 55, 60
Your
years
age.
old.
Now, we have another person, I don't know if you've spoken to, that's in this boat also, that he's got a long-standing offense, and I was told it was solicitation of prostitution, but then I've heard that that might be a conflict, so I don't know. But would that fall in the same category as
That'd be
rape
sexual-
or?
That would be
yeah.
sexual.
You wouldn't be eligible,
Yeah.
period. And we gotta think, there's also parents out there that, we gotta think about their concerns. So I don't make it too liberal, but
Yeah.
I agree with Chuck to some, I hate to have one incident change, define the rest of someone's life. So,
Let's keep in mind, this is minor assault and things like that are not covered under this
Right.
exclusion. This is aggravated assault, and I believe the offense that we're talking about was actually aggravated assault with a deadly weapon. So,
Well,
just-
hence the 30-year time period.
So when we do, I guess we do an FDLE background check on these folks, are there different levels of background check? And when we get that, does that give us a conclusion, or it just says, hey, here's the facts, overlay that with your policy, and we make the conclusion?
I would have to let David or Jessica talk about
Jessica can-
there are different levels of background checks, but I don't know which ones you guys run.
We just do the name check through FDLE, the name check, and anyone that was arrested is what comes up on there.
So, but then,
And we don't do the fingerprinting just because of the cost.
okay. So that report doesn't say, hey, this is a good guy, a bad guy. It just says, here's the facts. This is the arrest report, and then we overlay that with our policy.
Right.
Okay.
But that is separate from an association background.
Mhm.
Right. Okay.
All right, so it's the pleasure of the board whether we want to go forward with changing the policy or let's leave it alone. It's up to us to decide that. It's been brought up. I mean, we can direct staff to, I need y'all to tell me what you want to do.
Chuck, you started talking about it. If you
Well,
want to do it,
I'm
brother.
looking at it, I'm going, 19-year-old and a 57-year-old they're two different people. And so
Randy suggested a 30-year
I can live with a 30-year.
proving,
We'll need some more, you'll need to tell us, after, so if they don't get any trouble after that 30 years, any trouble at all, or violent?
I'd say violence or another felony.
Felony.
Yeah, I mean, the initial one is a violence charge, if they get another violence charge, probably even if it's not aggravated with a deadly weapon, but it's still a
violence charge,
a
yeah.
domestic violence or, something like that, and there's still a track record. I wouldn't even have a hard time dropping it to less than 30 years as long as we can show that they are a different person, because I think all of us are a different person than we were in 1984. Hopefully we are. We got smarter.
But on the flip side of that, we got to remember, we got parents looking at us right now saying, and for whatever reason, they'll say, I don't want my kid going out with a convicted violent felon
Right.
being a coach. And
Yeah.
that's all they're going to see is you're letting the guy coach that's a convicted violent felon. So
well,
And we also need to be able to administer this.
you got to take into account too, this particular gentleman has coached out there
Yes.
before this policy
right.
Right.
20 years.
eons. So, the policy made him, well, it didn't make him, it revealed what his violation with the law, and so that came to light, and we had to make him quit coaching. So,
Mm-hmm.
I hear what you're saying, Randy. The parents see that, and I agree. I don't want my kid to be out there and somebody trip off the line, and out there sometimes things get heated at the ball games. If y'all been out there, you've seen that. So,
But after 30 years, I think, as long as there's a track record of no violence after that,
okay, well,
Sounds like we have multiple policies. The county has a policy, association has a policy, 4-H has their own policy, because you have to get fingerprinted and background checked through University of Florida as well, so you might want to check their policy and see what it says.
okay.
We bring back some choices with a combination of those policies.
And I mean, I'm still on the same page of if that is who is running the field, then their policy is the policy that matters. Exactly. And so if the association is the people that are responsible for the background check, this is what I'm asking. This is what I was asking earlier, Jess. They are not responsible for the check?
We did the check.
Right. But an association, they do their own. And just like he said, 4-H does one, softball association does one,
whatever's more
football
stringent.
does one. So we need to all get on the same page with what we are doing.
Well, I can envision that we may have a policy, let's say theirs is more stringent than ours, and, okay, the county approved me, I'm good. Okay, yeah, you're good to be on the county property, but you're not good to be a part of our
Exactly.
association. I mean, I would defer to them if they wanted to make their policy more stringent.
That's
They wanna make it
exactly
more
what I
stringent.
mean.
Yes.
Exactly.
Yeah,
Yeah, we should set the base, and then if they want to make
Only
it more
property
stringent.
related.
So if we set the base, for example, at 30 years, some association could say, no, we don't care if it's been 100 years, we're not
That's
going to be
right.
able to coach.
right, I think that we should allow them to do that.
Yeah, oh, yeah, absolutely.
Probably a good idea.
Yeah.
So Chuck, are you making a motion or no?
I'll make that motion.
What is the
What is
motion?
the
What is
motion?
the Yeah, no, I don't
Ellie's
think
got
so.
So we come back with possibilities to change our ordinance to allow individuals that coach that haven't had a repeat offense in the last 30 years,
For just the violence or?
Non-sexual.
non-sexual.
What, Jessica?
And
Violent felony offense?
Or misdemeanor.
or
Can somebody show them the policy so we can?
Yes, it's right here. It's right here.
You can have it, Chuck. Even though it's got my name on it, you can have it.
The second page.
I would say violence or felony. The first offense may have been, violence, but if there's another felony that's
There's
not.
another felony offense, that should eliminate.
Yeah, 'cause some reason these coaches want to get out there and get mad.
Yes,
It's
if they have
crazy.
another felony offense, then they're
Listen,
eliminated.
I've coached my entire life and I never got mad, so
Do
that's
we
crazy.
understand the motion now?
No.
Okay, they're gonna come back with us with staff. Staff's gonna come back to us with a policy that, allows coaching after 30 years as long as there's been no reoccurrence of a violent felony offense.
Is it
Violent
violent
or
or just?
I mean,
a
felony offense.
Felony.
I would say violent or felony.
Violent ordinance, yeah.
Because you could have a domestic violence is not a felony, but it's violent.
It's non-sexual.
Yeah.
And make sure that's in there.
And one more request I would make, if you would, Chuck, is we move, if you've been convicted of murder, make that the same as a sex offense, that you cannot, no matter what.
It might even be higher, but yeah.
Okay?
I have no objections to
All right,
that.
Yeah.
Okay.
so I'll second your motion.
All right, we have a motion and a second. More discussion? Any citizens? Didn't have a chance to do that, but is there any citizens that'd like to speak on it? Okay,
I
hearing
would.
none?
He does.
Okay, come on. State your name and address, and got 3 minutes.
My name's Adam Carr, 95 Fox Run Circle. I'm the vice president of the Wakulla County Youth Football Association, which the guy that filled out the background check for. We do our own background check, but we usually go through the county, and then we make our decision based off of that. Like Ms. Messer-Smith said, we have our separate one, not including the county. There was issues that came off between a high school coach, which is the reason why it went from, I think, from county to state. And we had a couple coaches that failed the background check a couple of years ago. One had a misdemeanor, and his 7 years passed. Now he's back out there coaching again. This guy has a good track record. He's always been out there at the games, at the practices. He's just not allowed on the facilities, at the fields during the game. So we do our due diligence just like y'all do, but we kind of look at the same perspective as Mr. Hess did. This guy did his time. He showed his goodwill. He showed good sportsmanship. And we feel like it's a way of him, giving back to the community, giving back to the kids. I believe that the amendment that y'all are looking at is fair, and I'd appreciate it if y'all make a motion for it to pass by.
Okay.
Thank you.
Thank you.
All right. We'll vote. All for the motion?
All right.
Aye.
No.
We can't
Can't pass it.
pass it.
Okay, then we'll have to bring it up again.
Okay, well, just hold on up. So we got all for the motions.
To bring, for staff to bring you back
Can we
an agenda item.
get that done with a 4-1 vote, or has it got to be a 5-0 vote?
For staff to bring it back.
5-0, wasn't on the agenda.
Bring it back.
Wasn't on
You
the
guys could
agenda.
bring, a commissioner could bring a written agenda item back at the next meeting, and it can go with a 4-1, but right now it needs to be a 5-0.
I'm still there.
But wouldn't we have to be on the prevailing side to bring it back? Or does that only
Not at the next
cover
meeting,
agenda
at the
items?
same
I'll
meeting,
withdraw
the
my
prevailing
second.
side
There,
will.
that resolved it.
And you gonna bring it back, or
I
Chuck?
can bring it back.
Bring it back to the agenda item, Chuck.
Oh, yeah.
All right, that resolves that. Mr. Thomas.
No, I'm good, thank you.
Okay. Randy?
I don't think so, David. Am I supposed to talk about it?
Quincy?
Nope, I'm good.
And I don't think I have anything. I appreciate your time tonight. Any other business we need to resolve? All right, we're
Motion
done.
to adjourn.
Adjourn. Thank you.
Thank you.
That's your first dissenting vote. Very impressive.
Randy.